Okay, we're going to go ahead and get started here. We had last week the long-term care ombudsman came in and to give a presentation of the long-term care report. And we had, she raised a lot of concerns, which if they're, exactly as what was expressed, I think that we've got a problem. So rather than me trying to resolve it or this committee resolve it, I thought, well, let's bring the experts, the people that know this area. Because I also think that when any of us, whether we're a client or a family member of clients, is that we should bring these things to the attention of the right people to make sure we can fix them. Because if you don't know that they're broken, you can't fix it. That we just know. So, Camille, I appreciate you coming back here for us this week. And this isn't to pick on anybody, just let's try to see if we can't resolve some of the issues that you presented to us last week. So we'll kind of let you start off with things and, give us some of the stuff like you gave us last week, and then we'll let the respectful, whoever is, should address it to address it. Okay? Welcome to committee.
Well, thank you, Madam Chair and committee all, and for everyone who's here today, because I agree with the chairwoman that we should all work together. So what we brought to light was multiple issues, and so I don't know if you'd like to do one at a time or if you'd like to do a summary. Do you have?
No, I think we'll kind of do one at a time and not let them take and respond, so we make sure that we're understanding it and get their take on it.
Okay. So one of our top category of complaints are around resident rights, which could include many things. It could include care, could include dignity and respect, autonomy, choice, abuse, being free of abuse, neglect, and exploitation. And they're seldom cited. It is a seldom cited complaint when it is referred to be looked at. And so that is one of the things that we brought up, that it is one of the top complaints that comes in our office, and we feel like it should have more address to it.
Scott?
I'll start, Madam Chair. My name's Scott Bruner. I'm the Deputy Secretary. Take that off for a second. My name's Scott Bruner. I'm a Deputy Secretary at ks for hospitals and facilities, and that includes our licensure and survey and certification work. I've got with me here today Lacey Hunter, who's our commissioner over that same area, and she can speak to some of the statistics around what we have cited kind of in the time frame. I think that the ombudsman was referring to. So just maybe a little background about what we do as a state agency. Our role as the state survey agency is to enforce the federal regulations around skilled nursing facilities, long-term care settings, and also the state rules and regulations around those same kinds of settings. We operate on two tiers. We follow and enforce the federal rules and guidelines under a contract with CMS, the Centers for Medicare and Medicaid Services, and do work on their behalf. But we also enforce and survey for state requirements where they're a little bit different, or some of the settings that aren't subject to the CMS regulations. So that's our role. And maybe the other part of that is we also operate an abuse and neglect hotline, so that residents of facilities, their family members or loved ones can call and report concerns they have about the care, treatment, things that are happening to their loved ones where they live in skilled facility, any of the long-term care settings that we regulate. And based on those reported complaints, we triage them. So we give them a ranking of severity. We also categorize them by the category, general categories of what the complaint is. And then depending on the severity and what the complaint is, we go out and investigate. We can either go out on site and investigate. We can do by telephone, call the facility and the resident and the person making the complaint, investigate the circumstance, evaluate whether that needs another round of survey. So we actually go out and physically survey for that complaint, or if we can resolve it over the phone. So we have that regulatory function, but also it's information gathering, but it's also kind of triaging complaint function as well. And we do that for the for all residents in all long-term care settings. So I don't know if Lacey has handy the number of complaints that we've gotten where we categorize it as a rights restriction. I do think, I'm not the expert, but I get these kinds of questions from time to time. Sometimes we don't categorize a complaint the same way that the long-term care ombudsman would. Some are really clear, some are a little more nuanced, or we'll put it in a different category than just a rights restriction. But we can talk more about how that process works if you've got questions about it.
So then, Camille, do you then, on this particular issue, do you contact the agency to do follow-up on that? Or is it communication with the facility that you're concerned with that you feel like should be cited? Or do you recommend that the individual contact the hotline? Or what action do you take?
All of the above are good actions to take. And so one thing that we can do with resident consent is we can take further action to do some of those, help them do some of those things. Residents in nursing homes have a really hard time sometimes with technology and communication and reaching people and being able to call and get someone the first time. So actually even making a call to the hotline is problematic for residents. When they call and if they're not able, if there's not enough staff and they're not able to get that call answered promptly, it is very hard. For them to call back and do that autonomously and safely is really hard for residents in nursing homes. For us to follow up, and again, for us to follow up, there are 7 regional ombudsmen that cover the entire state. So our follow-up is honestly limited, but we do our best. So the hotline could be made probably more consumer-friendly, I think, for one thing. More ways to do that. We get complaints through our intake, through our website. It's a very rudimentary one, not like DCF has, but a very simple one. And I was reviewing before I came over here, just since I came to you last time, to look at the kind of complaints that we're getting. And sometimes we offer those folks to, if they want to just forward that, we give them an email that KDADS has, which is not always publicized widely, although I think they have put that on the website here lately. And we encourage that to continue, because they sometimes can just forward what they sent to us. We send the complaint to them if it's one that should go to KDADS as well. And we ask that they can, if they tell them, instead of having to type that all in again, if you'd like to forward that to the complaint line, that would be appropriate to do that. So we try and facilitate what you might say accommodate, the needs. So one other piece of the puzzle is we believe we should probably have more information. When KDADS has made an investigation, has conducted an investigation, in a case where we believe we had more information and we're not understanding why they were not able to cite, we believe that there is authority for us to have a better look into what they did or they did not do. Again, our staffing is limited, so our ability to do that would be somewhat limited. But when we could do that in a case, we were very, very confident that it should have looked different. Our ability to do that would probably bring to light maybe what is or is not happening, probably with some very good reasons, and sometimes we don't know if they're good reasons. We just don't know. That's the answer.
Scott, what do you think on that? I mean, we're problem solving here today is what we're doing, because my deal is I don't want to hear complaints and not solve it. And I think there may be a disconnect. I'm not sure what it is. So what could we do on that? Because they're not staying, Camille, they're not staying anonymous necessarily with you. Would that be correct?
Now, I might need to ask you to clarify that for me.
The individual that's called you, are they staying anonymous, or they tell you who they are?
So it depends. Sometimes one way and sometimes the other. If they are anonymous, then we all have limitations, quite frankly, about
But
what.
you can't solve it if you don't know who they are,
Right. And
where
so that's,
they're at.
so that's true, and that's true on both sides. But when it is someone that has provided us information, and we believe we have more information, we don't know what the state agency has taken into account when they look at those cases. And so we just don't know the answer. We believe that state law says we do have access to those records if we wanted to review that.
So is the agency telling you no?
We haven't got there. We haven't got a hard no yet, no. We also don't necessarily ask and get to have those records. So we'll let them answer that.
Either you or Lacey, it's whichever you want to do, Scott.
Yeah, I just think it might help for us to describe the investigation process a little bit too, because I thought I turned it, did I turn it on? Sorry. Scott Brunner with KDADS, testing the microphone. Okay, so it might help to have Lacey talk about the investigation process, because
Okay.
we do, we get the complaint and we investigate it from, try to gather input from other sides, the facility's perspective, the person who makes the complaint, because they're identified, family members who might know something. So we get, I don't know that it's more information, but we have an obligation to gather, to investigate the full complaint, which, and there may be some elements of that we wouldn't be able to share. But
Okay.
if Lacey could describe that process, if that would help.
Yeah, let her do that, because I think what I'm hearing here is if we're not following up with it, and a person wants to remain anonymous, which is not helpful at all to resolve anything, is I'm not sure that we should be taking these anonymous calls, because you can't investigate them, they can't investigate them. So Lacey, you want to give us the process, please?
Well, I will start with our hotline has to provide the option for a caller to remain anonymous. That's a federal law. They have to be able to remain
Are
anonymous.
you opposed to remove, yeah, I'm sorry.
So that's kind of one thing where we do have to allow for that anonymity to be a thing. It is part of the federal law that our hotline allows for a contact to be anonymous. So when we get a complaint, when someone calls in our hotline, emails our hotline, faxes our hotline, or walks in person, they have all of those avenues to reach our hotline from. We only staff our hotline with registered nurses, and at that time they take the intake call. There are certain parameters that they have to have answered once they figure out specifically what type of facility it is. So our hotline runs the hotline for all of the oversight for the certified facilities that KDHE licenses as well, such as hospitals, surgery centers, things of home health agencies, things of that nature. So once we have identified whether or not it is a facility that is licensed with under KDADS and under our purview, we then take those complaints and we triage them. And we triage them anywhere from an immediate jeopardy down to just a referral to a different agency. And that's based off of the allegations and the information that the complainant provides our staff. Once we have triaged it, it is then disseminated to the regional offices for them to begin an investigation or to put into a current investigation or plan as they plan their surveys out for when they can go. And how many days we have before we can investigate a complaint is based off of that triage level. So if we triage a complaint at the IJ level, we have 2 business days to be in that facility to look at that complaint allegation.
So do you see a problem with some communication between the agency on these types of issues and the ombudsman?
We're required to notify the Ombudsman's office when we enter a facility and what we're entering about and ask if they have any additional information they'd like to provide.
Okay, so that's not really a problem, Camille, if they're giving it to you.
Well, what that is they notify us that they are going in a facility, and that is, the intent of that is for us to provide them information so that it helps what they're going to look at in the complaint. It guides
Right.
that. So that's true. That is true. What Lacey said, one of the things that came out of that, I heard her say referral to another agency. So an example would be, we have people come up to us and say, we made the complaint. One of our things we talked about, those guardianship issues, or overreach of guardians, or that kind of thing. So what we found is they go back and there is no complaint. And I'm wondering, as I hear her speak, is if that indeed is even, of that resident rights restriction is getting screened out somehow, that there is no complaint to see.
To see
That's what I heard, or to be able to go back and say, what happened to this? There is no, if one of the options they have when they get a complaint is to just refer that to another agency and say it wasn't a complaint, we don't deem that a complaint, that they may not even be capturing these complaints that are resident rights restrictions.
Lacey? And again, if I call Lacey or whichever one needs to answer, feel free. Go ahead.
When I say refer to other agency, it means when we identify that it is over another agency's purview and that we at KDADS don't have any purview over it. Our hotline is federally mandated and outlined into which entities should be reporting to our hotline. There are other hotlines in which they are the main entities, such as APS. That is one of the big ones where we refer out to, and also the law enforcement agency when a criminal act has been alleged.
So how do we make the disconnect that Camille feels versus the system that we're operating with?
I don't know how to, I'm not sure how to answer that. We take in what we're given. If what they have alleged is alleged for a resident rights violation, it's coded that way. That's one of the main codes that you can code in our complaint intake system. And resident rights covers quite a gamut of things, but within that you would find those transfer and discharge issues within kind of that one. And there's a few other tags, but when you're looking at how we intake into the complaint system, we don't triage at the specific citation level. It's at very generic levels that are outlined within the federal government's program.
Okay. So perhaps what we could have happen, and I'll come back to you here in a minute, Linda, is that, maybe the agency, and then if there's another agency that needs to be involved, is figure out what we could do to make sure that that kind of happens. Not right here today, but you guys have a meeting. If it's something we need to change via law, then we can take and do that. But I want it to come from the experts and not just be legislative driven because we heard something. Linda, you had a comment?
Thank you, Madam Chair. Linda Mowbray, Kansas Healthcare Association, Kansas Center for Assisted Living. I guess from the facility side of things, I feel a little bit of a disconnect when we have what the nature of the complaint is. The complaint itself, if it's about the guardian or a conservator or not having access to your personal funds that are controlled by a guardian or a conservator, that's not the nursing home or the assisted living's responsibility per se. So the state agency that licenses us, that surveys us, that looks for compliance with us, that particular component, it's not within their jurisdiction because it's not within our jurisdiction. If an outside person is a guardian or a conservator, they have documents from the courts that the nursing facility or assisted living has to follow. And within that, if there's some malfeasance going on, the facility, if it's financial, the facility may choose to or would be compelled to report that through law enforcement, whatnot. So it could be looked at. But the role of KDADS isn't to come in and make sure that everything's fine in all areas that we touch, so that a conservator or guardian isn't doing something right. We could get in trouble for not reporting it, but not for preventing it or trying to stop
You can't
it.
necessarily, present that on the guardianship, and I think there was a lot of things that were brought up on guardianships, and I know Representative Barker's got a comment here, because as I went back and we were reviewing the conversation, it was resident goes into a metro hospital for surgery, wants to go home, hospital disagrees and wants to send to a nursing home, hospital securing attorneys, filing guardianship, and I think some of it might have been with, was it when attorneys weren't being assigned for guardianship? So what I'm going to do here is, you've kind of heard that. Let me go to Representative Barker, because I think he's a little more expert in that area than I am, and I'm going to let him take that up with all of you.
And I would be glad to do that, Madam Chair, but I have another question that
That's
I'd like
fine.
to go to, because I want to thank Ms. Russell in our conversations last week. I had a specific constituent problem. The family had their mother in a long-term care. They had put in cameras in the room where they could, in the evening, they could watch her. They saw one of the aides abusive to their mother. They had it on film, which is very unusual. I suggested they go to the sheriff's department and have him arrested. They chose not to do that. They went to the facility. They did terminate him. He was one of those contractor types. And I guess my question, are they not supposed to register those firings of abuse with KDADS? Because unfortunately, a week later, he was working in another nursing home in Enterprise, Kansas, which is about 10 miles away, where he was also terminated. And then he got assigned back to our hospital, who owned the first long-term facility.
Yeah, no, it's still on.
Executive
So
director
it says
saw him
unattending.
and told him he could leave. They weren't going to take him. So is there an obligation on the part of the facility to report those individuals? And is there a list that they go on where other facilities do not hire them? And how fast does that happen? And that may be Scott or anyone.
So what kind of happens is when an individual has been alleged of a criminal act, they then would have to then stand trial in a criminal court and be convicted.
Only if you have a complaint.
I'm sorry,
There's many reasons why families choose not to do that, because the victim would be their mother and who may not be able to testify. So they chose to go to the agency and have him terminated. They were quite happy with that. The problem is he came back 10 miles down the road in another nursing home. And then after he was fired from that, when he come back another 10 miles to our hospital, and the director of the hospital saw him and said, just go home. But does not a facility have the obligation if someone is, because very seldom do you have it on tape, do they not have an obligation to report it to KDADS? Because you have that 1-800 number or whatever. And I thank Ms. Russell for giving it to me, because I gave it to the family. But do you not register those people?
So there's kind of two parts to your question. So
Okay.
the first part is, yes, the facilities have a responsibility to report those incidents to us, to our hotline. With that being said, our responsibility is to make sure that the facility is in regulatory compliance and meeting the conditions of participation, depending on what type of facility it is. If the facility calls our complaint hotline and says that they were told of this, that they have fired the individual, they have done everything that they need to remove any sort of abuse, neglect, or exploitation concern from their building, our concern as far as the survey agency side of it, for who we survey as the facility, our concerns have gone down. So when we go to triage something like that, it's not going to be triaged at the IJ level, whereas if we were told that that individual is still working on the floor, that would be at the IJ level. However, since they've already terminated this employee and there's no imminent or immediate jeopardy that is no longer present, we would not triage it that high. The second part to your question is, how would they get on a list? So there is a Kansas Nurse Aid Registry list, but that is where I was kind of going down with that first path, with they would have to stand trial and be criminally convicted. And that portion of it I don't know a bunch about, because it's actually handled by KDAD's legal, not by SCC. But I can certainly find more information about that.
So you don't have, and I didn't mean to cut you off for a second, it's in, you don't have like a mandated reporting like we would have if that was a child and that was occurring at school, for example,
No, the facility is still required to report the incident that happened in their building.
to the agency, but not to law enforcement.
If they do have an obligation, if a criminal act occurred, to notify the law enforcement agency as well.
Well, but wouldn't we say that bullying or abusing an individual would reach to that level? And maybe it's something we need to clarify in law. This is what we're sitting here trying to figure out today.
I'm not sure what law enforcement would consider a criminal act, but that is their requirement, is if they think that a criminal act has occurred, they're required to notify law enforcement. And if we get the complaint and we ask them, if within the complaint, if we hear that we think a criminal act has occurred, we will ask them, but we are also required to forward that complaint to law enforcement.
Okay, Camille, you had a comment?
Well, I think that's why I'm saying if we could even randomly look at some of these cases that are situations like that, we would then find out what is or is not happening. Because if that, in that case, you should be able to call law enforcement in a case described by Representative Barker, and there should be a report to KDADS, but the facility, and we should be able to confirm there was, because they're mandated reporters. We also should be able to confirm that the facility did report to law enforcement based on what we understand. And if they did not, that would have been, I believe, a regulatory violation for them having not reported as they were supposed to.
Okay.
Okay?
So it sounds like to me we've got some type of a disconnect and Scott, you and I have worked together a lot over the years, I'm not a big fan of additional regulations or additional law, but occasionally it's definitely needed. So I think on this particular issue we look into it and see, what do we need to change? What do we need to tweak? Or maybe it's already out there and we're just not utilizing it properly.
Chairman Rachel Munger and Kelly Sumner.
I do want to just maybe draw a little bit of a distinction to Representative Barker's question. I think what he was asking, and if I got it wrong, he'll correct me, but the second part of his question about for that person who was fired from one job and then started at another job, what's the responsibility of that next facility to know the employee's history? So what our role is, and I don't know what classification that person had, if he was a certified nurse aide but I'll just assume that's it. So we do run the nurse aide registry. We log things so that as employers are thinking about hiring somebody, they can look at that list and see if there are any prohibited offenses that would mean that they couldn't be certified and then couldn't work in that role. I think Lacey's point was that we don't put somebody on that list of being excluded from employment until there's a criminal offense that's been adjudicated. So if the legislature wanted a higher standard of that, or just accusations or some other way of sharing that information facility to facility, that may be something we want to talk about as a policy change. But as a requirement for employment, you have to look at that list before you hire somebody. There has to be a background check conducted of that employee as well. But things won't show up on that background check if they're not through the criminal process. So
Okay.
I did want to draw that distinction. Just that's how one facility would know that an employee's not somebody to think about employing wouldn't be employable based on committing an abuse.
Madam Chair, if I may.
Yes.
The reason the elderly are often victimized, because one, if you file a criminal complaint, they have to appear in court. They're normally very poor witnesses, or the defense counsel will extend the case out as long as you can, hoping that the victim will die. And that's the reason they're victimized. There should be some way to put them on a list, whether they were convicted or not of a criminal offense, so that they can't just jump from one facility to another facility. And I do realize there may be some civil liability on your part, your agency, by doing that. But maybe that's something you're just going to have to look at and say, if especially very often, very seldom you're going to get somebody on tape. Usually it's he said, she said, or whatever, and then that's when the ombudsman has to go in and make a determination. It's very difficult to do. But I know they could have called law enforcement, and I suggested that. But I also know the lady's in her 90s. I know how the court system works, having worked there for 25 years, and the elderly are victimized because they may not have a recollection on that day of the incident. And there should just be some mechanism to be able to have the facilities register those people. Not saying they couldn't get hired, but if it went to a new facility, they went into another job, they could be aware of that. It's just kind of a heads up. I would rather for them not to go and get hired, but I understand that part of it. But with that, I just wanted to make sure, I didn't know if we had a register, Madam Chair. I think it would be a great idea because I think some of these people do jump around. And the elderly are just very vulnerable to abuse, particularly in long-term facilities, and they can't speak for themselves or can't appear in court and testify as a competent witness. Thank you, Madam Chair.
Summers, but you can call me either. I'm used to it.
Thank you, Madam Chair. Rachel Mongrath, Leading Age Kansas. And I just wanted to hop in with the provider perspective on this issue because we're hearing from consumers, and the answer is we agree. It's been a long-standing, I've been doing this for 11 years, and all 11 years, what I hear is facilities complain and say, I know I fired this person for this reason, and then found out the next county over that this home, he's working there or she's working there. And we have asked those same kinds of questions and are always told that it's a due process issue. We are required to report it to, there's federal regulation that says that if we suspect, have reasonable suspicion that a crime occurred, we are obligated to report it to law enforcement within sometimes 2 hours and at the latest 24 hours. And KDADS does survey on that. And but outside of that, what we've had to just coach our members over and over again for our providers is that if you know that that person got hired in that next county over, we feel like you have an obligation to call that administrator in the next county over to make sure that they know who they've hired. I assume some people do, some people don't. If the person moves across state, I mean, it's really unlikely. But all we've been able to do is sort of an informal network to try to keep some of these people out of our workforce, because absent that, you don't have a lot of power there. And I will say that with the rise in staffing agencies, we've heard more and more complaints of being concerned about people facility hopping, and that they really don't have control because it's who shows up from that staffing agency. So.
Thank you. I wanted to bring up a couple points, and thank you for bringing that up, because I do think there should be a central registry for those who have been let go for a criminal act. I also know, having had conversations with many people up here today, is that a person can be hired, which includes those new TNA positions, which haven't been certified, where they've gone through a background check prior. And they are allowed the facility 60 days for those individuals to work before that process is complete, and that they have that back. So they actually can work in a facility for 60 days and could have easily have done what you're talking about right now, and that we are exposing our residents, our seniors, to those individuals. So I think that's a concern in and of itself, and I thought I should bring that forward today too. So I hope it's helpful to share that information.
Linda Mowbray. I'll come back to you, Rachel. Go ahead, Linda.
Linda Mowbray, Kansas Healthcare Association. Two issues that I see with this from the facility standpoint, from the provider standpoint. One is, if you have fired someone and you've done your due diligence with reporting to the agency, reporting to law enforcement, whatnot, the thing that you can do is, when someone down the road calls and wants a reference on the individual, they're not eligible for rehire. Or if you're not comfortable with that, well, hang on just a minute. Let me get their file. It's kind of big. You know, there's a lot of employment details that our homes cannot give out and should not give out, but there are ways, and if you are checking with your network and you are checking references from individuals where they worked before, then some of that you can catch. The other piece of this is when it's agency, as you described, Representative, it's the agency that is the employer, and the facility is the contractee. So while the facility is ultimately responsible for what goes on within their walls, they are not doing the background checks. They are not doing the due diligence that they would on their own employee. That's supposed to be on the staffing agency. And a piece of legislation was introduced last week that I hope you'll be hearing more about, that looks at tightening up some of those controls on staffing agencies so that they are responsible, that if they know their employee got fired from my home, I can't send them down to Rachel's home without some oversight, without some training, without some additional responsibility. I can't just keep making money on that person and sending them out knowing they're getting fired from place to place to place. So hopefully we'll have an opportunity to discuss that more next week.
Okay. Well, and it kind of sounds like to me that unless there's something in law that prohibits it, why can't the long-term care ombudsman have more communication with the agency? Because we hold you guys highly responsible, and then we come down to the actual providers, you know, when we have questions and stuff. So it sounds like to me, Camille, we need you communicating with them more so that they know what the problems are. Because we're not the ones to solve all of these, but they are.
Thank you, Madam Chair. We appreciate that opportunity, and we'll absolutely do that.
Okay, and then going back to what I had interrupted the representative on with thinking that's where he was going, that's what happens when I try to get my crystal ball out, was the discussion was on involuntary guardianships. Resident goes into Metro Hospital for surgery, wants to go home. Hospital disagrees and wants to send to nursing home. Hospital securing attorneys, filing guardianship. Resident not present at hearings, not represented by attorney, no due process, no notification in advance, and that's kind of your area to be our expert on this committee, Representative Barker.
It concerned me when she brought this up, that folks were having a surgery or whatever and wanted to go home, and it was the hospital that made the decision, not necessarily family members, that a guardian conservatorship should be implemented. And then it's going to be indicated to me, too, that then the hospital gets their staff attorneys or someone affiliated with them to file under Chapter 59 a guardian conservatorship. They appoint or get an attorney to act as guardian ad litem. Here's what gets a little twisted. The guardian ad litem has an obligation, in my mind, and I think the KBA would support me on this, that they need to go out and visit with the proposed patient, and that if there's any possible way that proposed patient should appear in court and make the court make a determination of whether a guardian, whether a conservatorship or guardianship should be in place. Now, I went to, when I was the court, I actually went to nursing homes and had that proceedings. I took the court reporter with me, and we would put it on the record. But from Ms. Kelly, or Ms. Russell's indication last week, that is not happening. And I think personally that the hospitals are civilly liable if someone at some point in time, because they are not a disinterested party, and especially if they're using their staff attorneys to file those actions, and appointing a guardian. And then who is the guardian? Are they appointing someone else that does not know the proposed patient? Has no, maybe never goes and visits the patient? It just really, I mean, that's alarming. Because we're all going to be there one day. Hopefully our family will do that, but some, you know, we may not be that fortunate. And I think we have a moral obligation to find out what's going on. And if we need to contact the KBA, the Kansas Bar Association, and have them come in and explain, because I know it's an ethics violation to be a guardian ad litem and not visit with your client, even though your client may not may have some memory care problems, but you still have an obligation to go visit with them. And once you're a guardian, you definitely have an obligation to go visit the person that you're guardian over. And I know the state at one time had a guardianship program of volunteers, and I think we still have that. It's been many years since I used to do that. But with Ms. Russell's comments last week, I was just really concerned. And what safeguards do we have? And is KDADS involved, or who's involved in kind of overseeing these? Or is that some in the cracks that just fell through and said, well, that's the court's responsibility? Well, the courts only do what they're required to do. But anyways, that was my comment on the guardian conservatorships.
Audrey, do you have any comment at this time, or you want to kind of absorb it and then maybe have a visit later? Or I'm not trying to put anyone on the spot.
Madam Chairman, thank you. Audrey Dunkel, Vice President of Government Relations with Kansas Hospital Association. I apologize. I appreciate you bringing the issue to light. I can tell you at this point, as far as the perspective of the hospitals and what they are doing, there are a variety of rules that we are required to follow. CMS rules specifically about making patients aware of their choices, allowing them to select who might represent them in the case that they are not able to do that. But you also need to wrap that in with the responsibility of the hospital to provide the appropriate care for the patient and not send patients home who can't do things like feed themselves, you know, if they can't get up and walk across the room, they're a fall risk, those type of things. So there are always those balances in the process. I think what I am hearing you say is that where our system is falling apart is more on the side of the representation of the patient in this process than an activity by the hospital. It sounds like the guardian ad litem is not
I would
doing what's
agree
expected.
that, you know, the patient has rights. I want to respect those rights.
Absolutely.
And I understand courts are busy. Sometimes the attorneys file the guardian conservatorship. They have a name on the petition that has an attorney as a guardian ad litem. And it may be more of a KBA problem than anything, because the attorney appointed as a guardian ad litem, in my mind, and I think ethically, that they need to actually see the proposed patient, and that the guardian that is selected, it's just not a friend of somebody's, that they have an obligation, if they accept to be the guardian, they have an obligation to visit that proposed patient before the guardianship, so the court can make an independent decision. And if the proposed patient is in court, and I'm not sure how you know, whatever you need to get him there, you should get him there, or her, and the court can make an inquiry of them. Because if they have testamentary capacity, then they can say no. And the court has to make an inquiry to that as to whether or not they have testamentary capacity. And if they know who they are, they know their assets and their liabilities, they have testamentary capacity, and they can say no. Thank you, Madam Chair.
Audrey?
We are more than happy to provide you additional information on what we are required to do on our side, either through CMS or the state.
You want to get a little closer to the mic?
I apologize. We are more than happy to provide you a little bit more information about what is required from us by CMS and by the state, if that is helpful, but certainly willing to be part of improving this process.
And I think you're doing your part, and I don't mean to be accusatory. I think it's more on the part of the KBA, and I will be speaking with the Supreme Court about possibly having some additional training in that area for those attorneys who do Chapter 59 type of stuff, guarding conservatorships. But thank you so much for being here today.
Well, and I think, again, we're back to a situation of, you know, who Camille could report this to so that we make sure that it actually happens. Because the hospital may or may not be aware that it's happening. So, Camille?
In the event that the individual who has found themselves under what they cannot even believe has occurred, and they're already afraid of who has control over them, will let us do that in an individual case. We absolutely will report. But I will say, It is not a widespread practice that we are seeing yet in all hospitals anywhere, but we do have hospitals in metro areas that are using their own funds, using apparently an attorney, they are using the same attorney each time. They are paying that attorney 5 times what the other attorney gets paid to represent the individual. And they are not being seen, and the attorney that files for the guardianship for the hospital is also the guardian. Now, that's the deal. That's what I can tell you today. We will continue to work to get some of those individuals to allow us to share more individual information.
Representative Barker.
I think that's an ethics violation, and it should be reported to the KBA, because you definitely have a conflict of interest. Especially if, and I don't know these individuals or whether they have some type of financial security or not, but then that individual has free reign over their, although they do need to make an accounting once a year to the court. And that's just, to me, appalling. Thank you, Madam Chair.
Madam Chair, it may be that we can work with KBA and say we cannot provide the individual names, but we do not track guardianships. We might be able to let them know the area that this is occurring in, and maybe they can get information from a court that would lead them where they need to go.
Well, and if nothing else, it's like when you go to, well, let's take the KBA, for example, is maybe they can't solve what happened yesterday, but they can definitely give some ideas on whether or not, again, we need to make rules and regs changes, or that we need to make change into law to clarify things. You know, as I started this out saying, this is how do we solve it? Because there isn't a business out there that doesn't get complaints. But you have to solve that complaint. You just can't say, well, this was my bailiwick right here and that other was someone else's. No, because you've got a big responsibility on your shoulders, and people expect when they call you, you solve it. So it's like, you know, who do you need to call? Who do you need to go to? And I think that's where we're trying to get here today. It's not for us to facilitate that, but it's for at least some of the folks we have here in the room with us, and you and your staff, to negotiate with these people, or not negotiate, but have conversations, figure out what the answer is. You know, maybe a procedure that's out there, it isn't working. Maybe it's causing more problems, you know, but they don't know that unless they hear from you to help solve it.
Thank you. Thank you for the opportunity.
Yep. And then here's a couple I'm kind of tying together, and it was involuntary discharges, being discharged for being difficult, dangerous, aggressive, issues not being addressed by staff, person dropped off by family, wants to leave, thinks they have been kidnapped, damages, property, facility not finding out what is important to resident to call situation. And I believe that was directed at nursing homes, was that correct? And assisted livings? Who would like to comment on that? Because who do you report that to? Who do you talk to? Who do you tell?
We're not, facilities aren't required to report every transfer or discharge to KDADs.
They are or not?
They are not. The only entity that they're required to report all transfer and discharges to is the Long-Term Care Ombudsman's office. So they get the totality of all of them. We are not necessarily, facilities are not required to report all of them to us as they are to Camille's office.
Is that something that would be helpful for you to have or not? And don't say yes if it's not going to be helpful for what you guys do.
I don't think so. I think that we have some rules and regulations in place that allow for facilities to properly discharge and transfer residents, and there's no need to call our hotline and fill our hotline with something where they did follow the regulations. But I do think that there is, you know, a need for there to be ability for when there is a concern to call our hotline. I think one of the issues that happens there is, you know, Camille gets all of the notifications of a transfer or discharge, and, you know, she might see one that seems a little odd, and, you know, she can call over to our office and see if we have it. If we don't have it, she can't just give us the information. She has to go back and get permission from that resident before they can call in and make a complaint to us. And we can't really do much about it unless we get the complaint to start our investigation.
Okay. Anyone else? again, if the problem's been pointed out, how do we resolve it? Because I want to end this here today knowing that the Ombudsman is in communication with whoever's here at the table or anyone that's not here at the table today to be with, to try to figure out how we resolve these. You know, I don't know, excuse me, I don't know that anyone can, I don't know how you resolve a family dropping off an individual, and I don't know what a facility does. What do they do, Linda? I just pull up and I drop you off. What's going to happen? I like to pick on Linda.
Linda Mowbray, Kansas Healthcare Association. Fortunately, that's not a real common phenomenon. I think the incident that may occur more often would be the family member who is involved in the admission and then either slowly backs off or just kind of disappears out of the picture. That is heartbreaking for the home to see that happen, and the resident doesn't understand why.
But that's not unusual, Linda, for individuals to go into a nursing facility and not have any visitors.
There are some individuals that have no one around them. That is true.
Right.
But that's one of the facility's responsibilities with meeting the psychosocial needs of the resident is to, if they don't have outside visitors, if they don't have outside contacts, making sure that they do still feel connected, that they still feel valued, that they still feel part of a larger community to have a sense of worth or purpose. Is it a hard job? Absolutely. Would it be easier if there were friends and family coming in? Of course. But, that is one of the tenets that's laying at our feet, if you will, that we're to provide that extra support. Unless the individual's bill's not being paid or the family or guardian is not filing for Medicaid assistance, something like that, we can't compel the families to come and visit, and sometimes they have, dropped off our radar screen as well. If there is an issue with payment, that is one of the reasons that we would get a hold of Camille's office, even though our buildings are told they're not bill collectors. Non-payment of bill is a legitimate reason for an involuntary discharge. So if someone has been abandoned, then it's to everybody's interest to get them support, whether it is a legitimate guardianship or, find those individuals that are responsible for them and get them involved quickly.
Well, and Linda, what's in your facilities, which are nursing homes, correct?
We have nursing homes and assisted livings.
Okay. So in your nursing homes, what's the percentage of Medicaid versus private pay?
Depends on the home, but overall, it's about 60-40 for most of our homes.
Okay. What is your percentage of Medicaid private pay in assisted living?
I would have to say it's over 80%. In assisted living, traditional Medicaid does not pay. It's part of the HCBS waiver program, and it's a cumbersome process in our assisted livings. So, it is primarily private pay, and some do not participate in the HCBS program.
Right. Okay. Camille?
Well, I did want to respond to my comments about a person being dropped off and left, and then they're disoriented and they damage things. It goes to the involuntary discharge. It goes to them saying this person has behaviors we cannot manage, and they want to discharge them. And what we're saying is they're not meeting, it's their normal behaviors that you and I would probably had if we were in that situation, and that they are needing to meet their needs versus doing an improper discharge in the nursing home, in the nursing homes, so federally licensed homes. They are required to send us a copy of an involuntary discharge notice. They are not required to give us that same notice in an assisted living. We are somewhat successful at fighting those improper discharges at the nursing home level since we started getting those I say somewhat, not always, but somewhat. There's quite a few tools at our disposal, including appeals rights. So if we got notice in the assisted livings, which my sorry folks out there that work for me, yes, more work, but if we got the notice in the assisted livings as well, and they had another tool in their toolbox besides the regulatory look that is done, because that's not that's not always immediate, depending on the situation either, but if they had the appeals right in the assisted living, so if we got the notice and they had the appeals right, those two things together, I think, would reduce some of these evictions, improper evictions that are occurring, and lots of trauma to people that happens when that is done improperly.
Because, Linda, how often does a Medicaid patient, because there's no lack of pay unless it's on the part of the state, get evicted or discharged?
I don't have statistics on that. I'm sorry, Representative.
Probably pretty small, because the state's paying it. So they're going to pay their bill, and we know where the state's at. So it would be more on cash pay, self-pay.
Self-pay or individuals that have depleted their assets and they have no one helping them through the Medicaid program, so they're in that pending window, and that does occur.
So is that something that the facility can help with? Because would you have an idea of that their assets have been depleted and that they need the Medicaid, and that perhaps we can put them, get them started on that process before the full depletion of assets?
Getting started on the application before assets are completely depleted is something that the facilities work really hard to do. And when they have good partners with family members or attorneys or whomever's helping the individual, that's done. The rule of thumb when I was working in the profession was that when you get down to that last $10,000, we better be starting an application. But we're going to start talking about this at $20,000.
But if they don't have family members, you're kind of between a rock and a hard spot.
You're in a pickle because unless the resident can sign and consent to get bank statements, to get life insurance, values and whatnot, prepaid burial insurance. There's a lot of information that's required, rightly so, for verification of eligibility for Medicaid. But it's not something that happens automatically or easily. The individual needs an advocate to help with that. We have, always thought that in the partnership with the Long-Term Care Ombudsman's office, that they might be able to assist us with that, and unfortunately, that's not been the role that they've played.
Camille?
Well, obviously, we do have limited resources. We encourage the facilities to get income and asset information when they do the admission. I don't know, that's something that was done with my family members. We gave that information up front so that if down the road there became another issue, they already would have some of that information to be able to assist. And so the nursing homes they can help assist with Medicaid. We are true, and it's crude, and I think we probably said it out loud when we get frustrated. We are not bill collectors, and we encourage facilities to communicate early, like Linda is saying, to get information early, to use the other resources that every business has to use to collect money. If someone owes money to almost every other business, they have to sometimes make claim or sue for it. And they don't take those steps. They don't take the steps that businesses have to take to collect money. And they just want us to come out and somehow magically get someone to do what they couldn't get them to do. So it is not something that's not resident directed. We do try and explain to residents, though, that they do owe the money, that is a reason that they can be discharged, that some of the risks of making that choice, and try and talk to them about, would you want someone to help you with that? Most facilities do help them if they're willing to work with them.
But Linda, isn't it, I believe we have a law on the books that even if you're coming into a facility as a self-pay, there is still a financial assessment that's done before the individual enters the facility, correct? I'm now pulling back in cobwebs here. This is kind of scary.
Right. In our nursing homes, you know, individuals come in from the hospital on Medicare. They come in from the community and maybe private pay or through some additional funding with the VA. Most nursing homes do due diligence and gather financials from the individuals. Many people come to our nursing homes, though, on a planned brief stay, a less than 30-day stay, or maybe at the most a 6-month stay. Individuals that are not coming, that planned on staying, but end up staying, how much of that personal financial information are you giving at the beginning? How much do you wish to disclose? You know, that is something that the facility does talk about. Do you own your own home? You know, monthly income. But to require, I do not believe there's either federal or state regulations that requires that information to be gathered. Some facilities do consider it as their policy.
Yeah, I'm going to have Jana look in, because I'm almost sure that there's a statute, and I don't know whether it's set for the short stays or the long-term stays. And normally when a person comes in via Medicare through it, that's for skill stay, which is like 100 days max for skill care. A lot of people don't realize Medicare doesn't pay for long-term care. That's Medicaid or a long-term care policy, or they're going to be paying out of their pockets, one or the other. So we're going to have Jenna look that up. We're kind of going to refresh ourselves and see how that part could play, what that could play in some of this. We also had using medication to control issues such as antipsychotic drugs, not given right to refuse medication, source of diagnosis unavailable. Yep, that's just one area. Camille?
Yes, and those are things that are being looked at across the nation and issues across the nation and through some other committees as well. And I would say that there's so many things I can say about that. And one thing the words haven't popped out of my mouth yet today, but being able to have staff be better educated and trained to deal with individuals who are in difficulty or have dementia, and us being able to provide that true person-centered care to them is critical. You asked before, our office is, one of our main goals this year is to start trying to bring forth more training and education in those aspects. We would like to see there be better criteria for the nursing homes and these assisted livings that we're allowing them to have locked memory wings. A lot of the folks with dementia are in these state licensed homes, which have less regulation. We'd like to see much higher criteria for the type of training that staff dealing with individuals with dementia have to have, and reduce those antipsychotics.
Representative Epley.
Thank you, Madam Chair. Camille, and I know you're, I'm sure, very knowledgeable about this, but to share for the group, some of the metrics about antipsychotic use and how that's trended, I have my own impression of that, and I think the committee would like to hear from you about that. And I just want to make then a comment to segue back to what you just said about training. I think a lot of these facilities, and some of you all can probably correct me on this or confirm, try hard to get better training for their staff, for those that have mental health events or that have, for sure, dementia. There's been such a shortage of staff through the COVID illness right now that it's really been hard to have the one-on-ones that are necessary when people are having a memory event or they're having a mental health event, that it's sort of been double trouble. I mean, there's been an increased awareness, but if you don't have the staff there, you can't do the one-on-ones. You can barely, take care of people, basic functions. But I want you to comment about metrics, because I have pretty good command of that. Wondered what your knowledge was on the metrics on antipsychotic drug use and anxiolytics And then maybe hear from yourself and others about these training standards and about staffings. So I'll leave it at that.
I'm not your numbers girl to remember things, probably why I'm not an attorney, names and numbers, but it has trended up. And I hate to quote because I'm not a numbers girl, but it has trended up more during the pandemic. Kansas had been had been at the bottom of the nation. It is no longer there. It is, I think, 39th. There's people here that are going to be able to speak to that better than I. So it has done well, but it has trended up this last year. I think and again, there's a lot that goes into that. So there is proper use, improper use, and how that's measured. I think there's probably somebody here to speak to that better than I as far as the numbers. I'm just going to be honest with you. And I would let anybody that would want to volunteer to do that. It is, but it's raised a couple percent, I know, in just this last, I believe, year in the reporting that I've seen. I just don't remember the numbers.
Thank you. Whoever comments, I'd like for you to specifically address antipsychotics versus anxiolytics versus other meds that have psychotropic effects. And I'll leave it at that. And I'm sorry, Madam Chair. Thank you very much.
Rachel. I could actually see you for a change.
Rachel Monger with Leading Age Kansas. And on the antipsychotics, the long-term care ombudsman is correct. CMS used to do quarterly reports, but a lot of that got delayed and messed up with the pandemic. But we did learn from Kansas Foundation for Medical Care relatively recently that we had started to creep up again after trending downward for so long. So that was really disappointing. It wasn't surprising, and it is because of the staffing and the general chaos from the pandemic, and Representative Dr. Upley described that perfectly. However, it is such an important subject that we already have plans in 2022 in the hopes that we are not always going to be in this place that we are right now. So for Leading Age Kansas, we already have year-long training intensives that we are setting up for our homes, and we are actually making them video training segments that are 7 to 10 minutes long to be used. And that is what we're trying to do is tackle the problem we have right now when it comes to training for staff, is because we're stretched so thin that what we're hearing from providers is it is difficult to pull someone off the floor just for an hour to do their normal required training, let alone person-centered care, antipsychotic training. Our training is actually aimed at psychotropic medications and antipsychotic reduction. In federal regulation, those are treated the same. We do have federal regulations that were enacted a number of years ago, specifically aimed at reducing antipsychotic misuse and overuse of psychotropics when someone could be, they don't need to be on those long-term, basically. There are short-term benefits to those things, but they were being overused in nursing homes, in general, in dementia care, outside of nursing homes as well. So I don't know if you want me to do something more specific on psychotropics, but our psychotropic stewardship program and training is really aimed at across the board and how you can address things in a person-centered behavioral health way instead of always a medication way.
Representative Epley.
So again, just for the greater good here for the committee, where was Kansas, say, 5 years ago, roughly, and versus being 39th currently? I think, obviously, I've done this my whole career, so, I mean, I've been a director of a nursing home. I know the data. I was curious if you could share that with the group as a conferee today.
Yeah, and the Ombudsman mentioned that when we first started the antipsychotic reduction, Kansas was last. We had the highest rates of antipsychotic use in the country. There are a number of factors for that, but the bottom line is we had to work on that, and we have worked hard over the years, and we've floated in the 30s, and so obviously we still have a lot of work to do, but it's something we have been working on steadily. It is important to us, and it has been really disappointing to see those numbers creep back up after so many years of working on it.
And Rachel, just let me interject here. That's based on meds per resident, is that correct?
So, Madam Chair.
Or Scott, yes.
Scott Brunner with KDAD. So we report every quarter to the Bethel Oversight Committee on this exact, not exactly this question, but the one that there's data collected on. So the federal measure is inappropriate use of antipsychotic medication, because there are appropriate uses for antipsychotic medications in these settings. So the measure tries to kind of suss out what would be inappropriate based on matching diagnosis to drug and things like that. And there are some conditions that are specifically excluded from that analysis that we can talk more about. But we, as an agency, we report on that to the Bethel Committee on a regular basis. We've been reported to the Senior Care Task Force over the summer. Be happy to provide that data that we've been reporting to the committee, so you have it at your review. The one limitation is there's the federal government reports that because there's a national effort that along the lines of what Rachel was talking about to address this question. At the state level, in our Medicaid program, one of the performance measures we've asked the three managed care organizations to report on is inappropriate use of antipsychotic medication in long-term care settings for their managed care members that are in long-term care settings. So every quarter we get a report of that measure by MCO for their members that represents a couple thousand people from each managed care organization. So we can give you that kind of national number for Kansas, which is broader. We can give you that number by quarter for Kansans on Medicaid that are in long-term care settings. The one thing that that the Bethel Committee, I think the Senior Care Task Force asked as well, is there a way to gather that information for folks that are in state licensed facilities, assisted livings, home pluses? They're not included in that measure. And I've got some more work to do at the MCOs to try to gather that, because it is information they have about prescribing, and the location of where people are living is a little different, but we think there's a way to make a modified measure for that. So we get then you'd have a better picture of the whole managed care population in Medicaid to pair with those other kind of broader views from the national level.
Were there further comments on that? Oh, I'm sorry, Kelly.
Referring to the antipsychotic use, though, I would like to also comment on the staffing issue too. The antipsychotic use, actually KDHE has a group, and I can't remember the name off the top of my head, that works on issues which includes antipsychotic, because they come to me every year for me to forward to APRN. APRN's within our association, and then the secretary goes through and chooses the APRN that we've submitted. I just don't know the name right off the top of my head, but I can find that out. But that's what they're supposed to be working on, and I know there's been some frustrations from the committee members themselves regarding that issue. I hope that's helpful.
Okay. All right, and because we've got another committee that comes in here behind us.
Can I comment on the staffing real quick?
Yeah.
Since that was brought up. There's a lot of concerns with staffing. I will say there probably will be a bill proposed that I'm happy to talk about at another time that we will not support. But I would say that with our CNA education, I was actually talking to a member this morning who is a CNA educator. And she said the one thing that she's hearing all the time from the CNAs is that they're not receiving enough education right now to go in and to work in long-term care facilities, which is actually causing part of the reason why you're seeing such a quick turnaround with CNAs too. And there are states that require, right now we're 90 hours in Kansas, but there are states that require at least 100 hours. And then what's been happening lately is regarding the CNA education is they're not able to go into the homes themselves in nursing homes and actually get that hands-on experience as part of their education. I don't know if it's just because of COVID or if it's because there's 169 facilities on the active bans list due to being out of compliance.
What I'm going to do here at this point here is I think, and I hope that you guys all feel like this was helpful and that we can start communication between our agencies and our facilities with the long-term care ombudsman, because you don't have to be adversaries. You know, you can help each other because you're going to see things that they may not see. And again, it goes back to my philosophy. It's not, if it's not reported, nobody knows it was broken. For the 7 of you sitting there, if you want to stop by the office after this meeting, Dave will be able to provide you with some of the highlights that we did not get covered. And I'd just like I would encourage you all to give those some consideration. And these were just comments that were made from our meeting when you presented last week. So if y'all want to go on the YouTube Legislature channel, you can actually hear them live rather than just the notes that we put together. But, kind of a start on, how do we improve it? What do we need by, where was I at? Oh my gosh, you threw me off. Well, no, he was giving me good advice, but I just wasn't ready for it. What can we do to improve our system? What do we need? And it may just be all of you talking with each other. And again, not involving us. We don't need more laws and rules and regs, but it may be more about procedures that each and every one of you use. Because our long-term care population is just going to continue to grow. Baby boomers started turning 65 in 2011. So we're hitting about the middle of that. So Scott, you got a comment?
I don't mean to make the last comment, but I value that that response. We meet, Lacey and I meet with Camille. We try to do it every other week. We've been pretty consistent for the last year or so. We started right at the beginning of the pandemic just because we thought our ability to get into facilities and do investigations was limited. We needed as many eyes to look at residents as we could, so we were working together, and I think that's really been a valuable, it's been valuable to me as relatively new to this part of the world to learn what's going on, and we've improved processes on our part. Hopefully it's been valuable for Camille as well. And we do meet with the trade associations on a regular basis as well for the same kinds of reasons. So you certainly have our commitment from KDADS to continue listening, continue trying to improve. We do have different roles, and you've acknowledged that, and different points of view and perspectives, but that doesn't mean we can't share where we can and when it's to the benefit of residents and family members, because that's critically important. We've all got to be rowing in the same direction as much as we can.
Well, and I think it would help us, because now that we've got all of this Zooming and WebExing and ability out there, you just never know what's going to happen in this Capitol, is that, and it doesn't necessarily have to be every other week with these other entities, but, maybe once every couple of months. And, I think that's where ideas and improvements and, common sense can kind of, grow from it, because they are our most vulnerable people. And, many times, I have been in many nursing homes and visiting family members or friends, and it just breaks my heart when every day or every time you come in, especially if you're there every day, and you never see anyone with a client in one of the facilities. It just, breaks your heart. I kind of got to where I'd just stop in and say hi or, different things because they just love to talk. They want that socialization and stuff. And I don't think any of our facilities intend to be negative, but I also know that, the clients sometimes can be difficult. They don't understand or they don't want to understand. It's hard. And if you don't have all your facilities, it's even harder. And that's what makes it so important, is for people to have, a family member or someone that has their best interests to address things. So I hope you found this encouraging and that we can, move forward. And now we found teams that everybody can take and work on this. And if you do find something that you need from the legislature, let's have that conversation and let's make it take and work. Because I believe that everyone that's sitting at this table has the folks that are responsible for their best interests at the top of the list. But you can't control every employee that you have that works for you. I am really kind of disturbed on what kind of a solution we can come up with the person that abuses or neglects or mistreats an individual. And I think Reverend Barker was right in the idea that person's not going to show up at court. So running through that legal process. So what is the alternative? And maybe you talk to some attorneys, talk to some of our judges that we have out here and see if they have ideas. Jenna, did you have something? Okay. And maybe, Scott, you guys could look up and figure out where that assessment, that financial assessment statute, we're not finding it. But and again, when I say pulling out the cobwebs, I'm going back, I think that was a discussion that at the time Senator Prager and I had actually had, because I was kind of surprised that we had such a requirement, even for self-pay coming into a facility. And I'm like, why would you do that? Well, it makes sense. If they end up spending down on their funds, it's good for the facility to be able to know to start heading that off on getting them set up for Medicaid if that is the decision that has to occur.
It does sound like a long-term care insurance discussion we probably had many years ago. So that does sound familiar. It might be, so we'll take that back for sure.
And I don't, maybe it's not state, maybe it's a federal. I do not recall.
It does seem like I mean, we can talk to you more about it, about just going through the assessment process, the entry to nursing facility level care, what that looks like for residents as they're going through that process, and we can describe that from a financial and functional assessment.
Yeah, when I'm pulling out the cobwebs, that's a long ways back with Senator Prager. So, all right, I want to thank everyone here for today, and I don't believe we have a committee meeting on Monday. Is that correct? So no committee meeting on Monday, and we do have a meeting on Tuesday and Wednesday and Thursday of next week. So make sure you're looking at your agenda. I am going to ask for, I should have done this at the beginning of the meeting, are there any bill introductions? All right, no bill introductions. I kind of like that. That means we work less. For our new members, you will find that just because I have bills in the committee, I don't hear every bill that comes before the committee. Anytime that I can give you breaks, I mean, I always liked it when I wasn't the chair because I could get things done because our schedules are back to back, and sometimes it's difficult to meet with folks. I know that our staff likes it because then they get to catch up on things, and maybe they're not here till 7, 8, or 9, or 10, or whatever of an evening trying to catch up. So that's the other reason that I do it. But we will address bills as they come along. If you do have ideas on and I think I kind of expressed this yesterday, on the CanCare extension, make sure you get those to Dave, and then we'll take those under consideration. For new members, those that have served with me for quite a while, I like surprises, but only if they're monetary. And so I don't like surprises in this committee, and I will try not to surprise you as well. So that way we're all working above board. It's like someone said, well, why did you show your amendment yesterday? I said, why shouldn't I show my amendment? Because, I think we've already figured out some ways to improve that amendment. That's why we did that. So let's stay in communication. You got questions, my door is always open. Feel free to come in and visit with me on it, and we'll move forward. So we are adjourned until Tuesday next week.